Judge Seals from the 20th Judicial Circuit. Judge Seals also is a member of the Task Force for Fostering Success. Judge?
Well, thank you and good morning. It is a pleasure to be here, even though I had to get in my car at 6:30 this morning and drive that lonesome road of I-75, which I've traveled so many times. But I suppose the reason I was chosen to be here was perhaps because Secretary Sheldon knew I was on this work group. But also I like to think that I'm here because I am part of an organization, I would say we're kind of a loose-knit organization, but in some ways a very tight-knit organization of dependency court judges. We call ourselves the Florida Council of Juvenile and Family Court Judges, and we have, I think, some of the most dedicated dependency court judges in the state who are in this organization and with whom we are in constant dialogue about various issues. And I did put out the message to my colleagues in the organization, which runs about 50, I believe, there are about 50 of us in the organization, to give me some feedback on what I should be talking to you all about this morning. And I got some, but I will have to tell you that a lot of what I'm having to say is based upon my own personal experience in doing dependency work off and on for approximately 11 years. So much of what I'm going to say has already been heard before, I'm sure, but I was asked to give a judicial perspective. And as I said, many of my remarks reflect my own personal perspective, but also reflect the more collective perspective of my colleagues. Our concerns fall into 4 categories, which I will state in the form of questions, because much of our concerns flow from the fact that we know less than we ought to know. First concern is when consents to Medicaid come from parents, is there consent and informed consent? Second, when we are requested to give our consent, are we satisfied that reasonable efforts were made to first obtain an informed consent of a parent? The third concern is when it becomes our duty to rule on a motion to medicate, what should guide our decision making? And fourth is that general issue, I think, which is kind of out there in the public anyway, and it certainly is shared among me and my colleagues, that is, are children in care being over-medicated? First, let me address the implied consent of the parent. According to the AMA, informed consent is more than simply getting a parent to sign a written consent form for his or her child. It is a process of communication between the child's parent and the physician that results in the parent's authorization or agreement to undergo a specific medical intervention. In the communications process, the physician providing the treatment, and I emphasize the physician providing the treatment, not a delegated representative, should disclose and discuss with the parent 6 things. The patient's diagnosis if known, the nature and purpose of the proposed treatment, the risks and benefits of a proposed treatment, alternatives to the proposed treatment, the risks and benefits of the alternative treatment, and the risks and benefits of not receiving or undergoing any treatment at all. Once a parent's signature on a consent form is obtained, does the child protection system have a duty to verify whether the consent was truly informed or not? I ask the question because I wonder if the AMA standards are being applied in all cases, or for that matter, even in the majority of the cases. I'm concerned about whether the parent really talked to a physician. I'm not sure if parents are given the opportunity to ask questions and get answers before signing. And I have doubts if parents really understand what they're doing. And I fear that parents may even be pressured into signing consent forms. That said, an independent verification of every case would be a burdensome process for child welfare case managers. I do not believe that it is our job or their job to investigate each and every case and determine whether or not the job was done. I think this makes the choice of the physician who provides care to the child very critical. Physicians who are knowledgeable, ethical, and trustworthy can alleviate concerns and expedite treatment. Nevertheless, case managers should be trained on what is and is not an informed consent. Should they gain personal knowledge that a truly informed consent was not obtained, they should report it to their supervisors. Second, unreasonable efforts. Getting parents involved in the decision-making process regarding the administration of psychotropic medications to their children is good reunification practice. Consequently, the doctrine of reasonable efforts should also apply to the efforts made to bring the parents into the informed consent process. Judges should not get involved in the process unless and until, 1, after reasonable efforts have been made, a parent cannot be located. 2, the parent located fails or refuses to cooperate. Or 3, when there is an issue over whether the parent's consent could ever be considered an informed. For example, in the case of a parent who may be too low functioning to competently give or withhold consent. The substituted judgment of the court should be the last and only resort of the party seeking the medication for children in care. The convenience of simply going straight to the court for consent is not good practice and should be avoided. Therefore, judges want assurance that reasonable efforts were made to first obtain the informed consent of a parent. And to the judge's consent. Obviously, the consent of judges, once the matter is properly before them, should be an informed one. Using the 6 elements outlined in the AMA guidelines, I wonder if that is the case. Speaking for myself, the information coming to me does not always address all 6 elements that I just described earlier, or does not always disclose enough information, or it is not understandable because it is written in medicalese or in illegible penmanship.